G'day troops, it's Mauro here. Today we're going to be dealing with the case of Barlow and CBT. This is a trial period conversation, and it's a conversation that happens in the context of a building labourer and a labourer relationship with their employer. As you can imagine, it's going to take less than 90 days to have this conversation, and effectively, there's a bloke, Mr. Barlow, he's a labourer, he's signed up to be a labourer. There is, however, some debate about that, because he's got some roofing and cladding experience, and one of his arguments is that the employer is sort of taking advantage of that a little bit by giving him some of that work, which is a higher, harder role, but paying for the labouring work technically at a lower, lesser rate. This obviously is part of the debate that's held at the authority, and in that instance, interestingly enough, we hear from the authority saying, no, that's pretty reasonable, you hire someone for sort of this, you're allowed to put a little bit around the edges of that, that feels a little bit around the edges of this, so we're not going to take that argument any further. What does have a bit more in the way of legs are the following two things. Firstly, no one can prove or is indeed certain that the trial period was signed up, i.e. the employment agreement was signed, before the employee began work. And because no one can prove that, it's an open question, it's not purely defined as it didn't happen, but because it's merely an open question, the authority is able to say, actually, this isn't going to apply because we know it must be signed before you start. Additionally, since there's here a failing, we know that the process of the dismissal, which was short and sharp, essentially it turns out they have a phone call, it goes badly, and during the course of that phone call, the employee is dismissed. There is no investigation, no process, no essential attempt to consult on the circumstances of the matter. So clearly, there is a failing here in terms of the dismissal process as well. Also, the courts have an interesting assessment here because they say, well, look, on the basis of that conversation and what's happened, we also know you should have given like a week's notice, there wasn't provisioning for pay in lieu, and you've just dismissed over the phone, so you also haven't followed those terms of the clause, which in and of itself can in fact invalidate its operation. And so as a result of that, the employee ultimately is entitled to roughly $25,000–$30,000 of compensation and total penalties. So what do we take from this? I think we take the obvious point. Trial periods are very strictly interpreted. If you get 99% of the process right, but 1% wrong, it will effectively deem the process wrong. And that's ultimately the key takeaway for a trial period. It has to be done right, it has to be done according to the clause, and the clause has to meet the legal obligations set out in the Act. Ladies and gentlemen, boys and girls, it's a short, sharp one from me. It is a pleasure as always. Can't wait to see you guys again soon. Have fun out there. Cheers.